Modern Real Estate Practice, page 105. Most states permit someone with a power of attorney, which means written specific authority, to sign legal documents for a grantor. The person having power of attorney has written authority to execute and sign one or more legal instruments for another person. The power of attorney will be a special power of attorney if it is created only for a specific act or acts. A general power of attorney provides authority to carry out all of the business dealings of the person giving it. The person with power of attorney does not have to be an attorney at law, but could be. Usually the power of attorney must be recorded in the county where the property is located. In practice, a power of attorney can be a great conveyance when all of the co-owners of a property are not available to convey title at the required time. A spouse who is out of the country, for instance, can give a special power of attorney to the other spouse so that the property can be conveyed when required. In some states, a grantor's spouse is required to sign any deed of conveyance to waive any material or homestead rights. This requirement varies according to state law and depends on the manner in which the title to real estate is held. Many states still require a seal, or simply the word seal, to be written or printed after an individual grantor's signature. The corporate seal may be required of a corporate grantor. Acknowledgement. An acknowledgement is a formal declaration under oath that the person who signs a written document does so voluntarily and that the signature is genuine. The declaration is made before a registered notary public or an authorized public officer, such as a judge, justice of the peace, or some other person as prescribed by state law. An acknowledgement usually states that the person signing the deed or other document is known to the officer or has produced sufficient identification to prevent forgery. After verifying the individual's identity, the notary public will also sign and stamp the document, which allows it to be recorded. An acknowledgement that is a formal declaration before a notary public is not essential to the validity of a deed unless it is required by state statute. However, a deed that is not acknowledged may not be legally sufficient for certain purposes. In most states, for instance, an unacknowledged deed is not eligible for recording. An important act that puts the world on notice as to who owns the property. Delivery and acceptance. A title is not considered transferred until the deed to the property is actually delivered to and accepted by the grantee. The grantor may deliver the deed to the grantee personally or through a third party. Title is said to pass only when a deed is delivered and accepted. The effective date of the transfer of title from the grantor to the grantee is the date of delivery of the deed itself. Delivery and acceptance are usually presumed if the deed has been examined and registered by the county clerk. In practice, is there ever a time when someone would refuse a property deed? It's possible. For instance, when property is contaminated by hazardous materials, the owner may find that no one wants to buy the property, and no one wants it even as a gift. A deed attempting to convey such property can be refused by the potential grantee. Transfer of title requires both delivery and acceptance of the deed.